Hello everyone. Today Liz, Diego, and I will be presenting to you three different concepts. First, we will start off with an introduction to harmonization of property law. Second, we will be covering harmonization of property law efforts within the European Union. And finally, we will end by speaking about the harmonization of property law efforts at a more international level. I hope you guys enjoy the presentation and take something out of it. Now I'm going to start off by introducing this concept to you guys. I'm going to talk about harmonization of property law, which can also be addressed as the unification of certain sources and principles of the law across borders in order to achieve certain common standards to make the law more accessible and easier to comply with. For example, the creation of supranational regulations or the mere drawing of common principles of property law. It is important to take into account that this concept has only been applied in recent years. Before, efforts to harmonize property law were hardly made. This is mainly because of two reasons. First, the fact that property law has an erga omnes effect. And second, the fact that regulations need to be very detailed, specific, and even technical since they affect third parties. As a result, since detailed and technical rules must be created in order to outline property law, harmonization between systems has not been easy. In one hand, harmonization of property law is an ideal principle to reach, since it provides with certain common grounds for the sake of simplification of the application of the law. When certain common standards and regulations are settled, this makes the compliance of the law easier for both individuals and even the state. Individuals will be more informed and they will know the law more into depth. And the enforcement of the law by the state will be easier since common laws will always be the ones to be applied. Harmonization of property law will eventually lead to the creation of uniform legal rules through the European Union, for example. This will promote transparency, fairness, certainty, and even predictability. On the other hand, it is quite complex to reach an acceptable level of harmonization, since it is time-consuming for the different jurisdictions involved, and there are certain expenses such as public finance, as well as certain social costs and effects. There are many different methods of harmonization. It may take place through binding international instruments, such as ratified conventions, treaties, regulations, and directives at the European Union level, or it may also take place through soft law, such as common principles, model laws, or legislative guidelines. Additionally, and finally, harmonization of the law takes place at many different levels. For example, it may be top-down by international or national legislations, as well as by judicial decisions or by following international standards, or it may also take place from the bottom up, such as by academic initiatives and research institutes that promote this information.
Now I'm going to be talking about the harmonization of property law at the EU level. So the EU has at its heart an economic objective, which is having a functioning internal market for freedom of movement of goods, services, etc. And it's important to know the difference between positive and negative harmonization, which the first occurs when legislation is made by the EU legislature, and the EU legislature adopts directives which member states must implement or transpose into their national law. And negative harmonization occurs usually through the European Court of Justice, and when the ECJ declares certain types of national rules incompatible with treaty freedoms, such as, for example, Article 34 of the TFEU, no restrictions on freedom of goods, movement of goods. And this is important because it's the main ways that the EU can affect member state laws and, in effect, therefore, property law legislation. So, to make legislation, the Commission needs an appropriate legal basis, which can be found in treaties. The TFEU, Treaty on the Functioning of the European Union, and the TEU, the Treaty of the European Union, are the most important ones, and the ones that we're going to be mentioning in this presentation. So, Article 288 of the TFEU outlines ways that the EU can exercise these competences to make legislation in the Union. for example, through regulations, directives, decisions, recommendations, etc. And the main ways that property law is done or affected by the EU is through directives and regulations. The difference here is that directives are directed at member states and must be transformed into national law to create rights and duties by the member states. It's less invasive and gives more discretion to the governments, to member state governments, whilst regulations are have a direct application in the legal order of the member state. Articles 1 to 4 of the TFEU outline the legal competences of the EU on different matters. And in some areas, the EU has exclusive competences, but in others, they're shared between member states and the EU. And in the relevant area for EU property law, which is policy area of the internal market, there is a shared competence between both. And therefore, the EU must still find a legal basis for its actions. And these actions must follow the principles of subsidiarity and proportionality because they are in areas that the EU does not have exclusive competence. And these follow Article 5 of the TEU. So Articles 26, 114 and 115 of the TFEU provide legal basis for EU measures dealing with private law, which in itself affects property law. Article 26 relates to measures that ensure the functioning of the internal market. Article 114 gives EU competences to enact measures of approximation, or in other words, harmonization of national rules regarding internal market. And Article 115 relates to issuing directives for the approximation of laws, regulations, or administrative provisions of member states which affect the internal market. And these articles have been used by the EU in the past for rules of European private law, for example, a directive on late payments. However, the Commission has stated that differences in member state legal systems has led to a distortion of the internal market, and thus it gives the EU an ability to act and a reason for harmonization of legislation. However, the European Court of Justice has made clear that there's no EU competence to harmonize law simply because there's disparity between member states and national laws. We saw this in Germany versus Parliament and Council, which related to tobacco advertisement. And competences of the EU are meant to be functional and directed at the functioning of the internal market. It is not enough just to state that the member states' systems are different. So now the Commission must make impact assessments to assess benefits of harmonizing legislation, and then use articles as a suitable legal basis. Furthermore, Article 345 of the TFEU states literally that treaties shall in no way prejudice the rules in member states governing the system of property ownership. So this is quite clear and literal in its meaning. It seems quite clear and literal in its meaning that the EU cannot interfere with member state private property. However, there's a problem with this because obviously EU property law does exist. In the past, this article has been used to block developments such as, for example, former Commissioner for Enlargement stating that EU cannot concern itself with matters of property law. However, the ECJ takes a different approach to this article. The restrictive interpretation of the article doesn't hold true, and it's more likely to meant to address the EU's ability to nationalize or privatize certain property and, its inability. And therefore, Article 345, according to the ECJ, is not an obstruction to EU property law or creates ability for member states to block influence of EU law on national property law. Finally, here are some existing EU property laws currently in place. Cultural objects, directive relating to cultural objects and the return of stolen cultural objects. As mentioned before, a directive relating to late payments, regulation relating to insolvency proceedings, directive relating to financial collateral arrangements, and directive relating to emissions rights, which is actually a new object of property law because these emissions can be traded and then relate to greenhouse gas emissions. Also, there are some future EU property laws in the works. For example, the Euro mortgage or Euro hypothec, um, which is meant to overcome legal barriers to cross-border home loans. It's currently in the stage of research. And also another example is matrimonial property law. There is currently a green paper, which is a document published by the EU Commission to stimulate discussion on a given topic at European level regarding this topic. Therefore, overall, the instruments outlined in Article 288 of the TFEU can be used by the EU to harmonize property law across the Union, given the legal basis provided by Articles 26, 114, and 115, in order to ensure the proper functioning of the internal market of the EU.
Hey everyone, my name is Elizabeth, and I will be talking about the international harmonization of property law. First of all, let's talk about some context. With the world's increasingly globalized environment with the exchange of goods and services, property, specifically intellectual property such as patents, trademarks, copyrights, and cultural property, is an area that has become very important by being more frequently litigated and has seen the interplay between multilateral and bilateral agreements and the resulting harmonization of local laws. And because of the surge in need for protection of such property rights around the world, organizations such as the World Trade Organization and the World Intellectual Property Organization, as you can see below, are key players, among others, to make efforts in harmonizing property law on the international level. Now, I will talk about specific examples of such agreements or progress that has been made in the harmonization of property law in the international level. First off, we have the International Institute for the Unification of Private Law. This is an independent intergovernmental organization, and its purpose is to observe and find methods of harmonizing and modernizing private law with an emphasis on commercial law. Examples of the ways that this organization has helped this harmonization is through some of their studies and drafts, which have led to the creation of international instruments like conventions, model laws, as well as legal guides. Specifically, as you can see right here, we have their Cape Town Convention of 2001 on interest in mobile equipment. This convention establishes an international registration system for the protection of mobile equipment, such as aircrafts, space assets, and railway stock, and therefore facilitates asset-based financing and leasing. It has already been ratified by 51 countries and applies even if one of the parties is not a contracting party to the convention, just as long as the debtor is situated in a contracting state. However, when it comes to the interpretation of these rules that are not mentioned in the convention, it will come down to domestic rules, which are then applicable. Next up, our example is with the United Nations Commission on International Trade Law. Its objective by mandate is to further harmonize and modernize law, similar to the organization I spoke about previously, by using legislative and non-legislative instruments, mostly regarding commercial law. When it comes to this commission, there are 6 working groups whose topics are procurement, international arbitration and conciliation, transport law, electronic commerce, insolvency law, and security interests. The last 2 I just said, which is insolvency law and security rights, are more relevant to property law, and the following guides and model law apply to each, as you can see here listed. Additionally, if you look at the last one, 2007 Legislative Guide on Secure Transactions is a supplement to security rights on intellectual property and was a guide where this commission actually worked with the World Intellectual Property Organization as well as other intellectual property organizations to ensure sufficient coordination between all of them. Now, finally, we can get into other efforts. Besides the UNIDROIT and UNCITRAL, we can see various forms of efforts in harmonizing property law on an international level. Here, we have an entire branch of conventions regarding cultural property instead of the intellectual property focus that I previously discussed. As you can see on the right is the list of these conventions. For example, we have the Hague Convention for the Protection of Cultural Property in the Event of Armed Conflict. We also have the UNESCO Convention of the Means of Prohibiting and Preventing the Illicit Import, Export, and Transfer of Ownership of Cultural Property. And finally, the UNIDROIT Convention on Stolen or Illegally Exported Cultural Objects. The World Intellectual Property Organization also has many treaties that are substantive, registration, and classification related, along with the world's most comprehensive source of data on intellectual property. Additionally, the WIPO offers alternative dispute resolutions, such as arbitration and mediation, to solve cross border disputes, which further supports the harmonization of intellectual property law. Finally, what does the future of international harmonization of property law look like? As mentioned by my colleague Laura, harmonization has its pros and cons. Pros include its predictability, its transparency, and easier compliance. And cons include its technical difficulties, time consumption, and cost due to the ergonomous effects of property rights. The future of harmonization definitely depends greatly on the cost, time consumed, and the cooperation to do so. But even with such cooperation, one needs to also remember one of the greatest challenges, which is technicalities, especially involving regional efforts. Because, for example, in the United States, property law differs by state. And so harmonizing just in the US, let alone harmonizing the US with other countries' property laws, will require a lot of technical processes. However, as the world is increasingly becoming globalized, the need for such international property laws is becoming ever so evident around the world. Also, with recent developments in technology such as biotech, computer softwares, and computer maintained and search databases, there is now a new challenge to face, and that is adapting traditional legal principles to these changing technologies. More so if such technologies are used on a global level rather than just nationally. Thank you so much for watching our presentation. We hope you enjoyed and learned a little bit more on the harmonization of property law.